Hi everybody, my name is Russ Tweiten, Vice President, Succession and Retirement Planning, and welcome to another edition of Transitions. Today we're going to talk about titling and the importance of titling and what titling means for your estate plan, whether it goes through a will or doesn't go through a will. We're going to go through each one and then we'll talk about the application in farming and ranching. The first one we'll talk about is sole or individual ownership. This is pretty straightforward. Most often we're dealing with someone who's single, doesn't have a spouse, or maybe an individual who's widowed. Any assets that you own in your name alone, you need a will to transfer solely owned assets. Then there's joint tenants. There are two types of joint ownerships. There's joint tenants with rights of survivorship, and then there's a joint ownership, which might be for a checking account or a bank CD or something like that. Joint tenants with rights of survivorship is a very common way to title real estate, such as your residence or farmland, pasture. This is a probate-free transfer. In other words, you don't need to have a will with joint tenants with rights of survivorship. The real estate transfers by operation of law to whoever the other joint owners are. And then there's a vehicle titling. This can be joint as well, but when you've got your vehicle set up as you or your spouse, this would be considered a joint ownership. When you've got your vehicle set up with you and your spouse, this would be tenants in common, which we'll get to in just a second. If you want to have joint tenancy with rights of survivorship for your vehicle, it's best that you title it in that manner. Now, I just talked about tenants in common. Tenants in common is split ownership, often known as an undivided interest. And so if you and your spouse own anything as tenants in common, you each have a 50% interest that needs a will to transfer to the other spouse. Tenants in common is a very common way to title land if we've got a potential estate tax. For example, in Minnesota, we have an exemption in Minnesota at $3 million if you don't have farming heirs or have a small business, or $5 million if you have farming heirs or a small business. Minnesota, we can get two exemptions if we've got our land titled correctly. If land is titled as tenants in common, on first passing, we can preserve that spouse's estate tax exemption with a special trust embedded in the body of the will. And so there's a real application in Minnesota for tenants in common ownership. Then there's the beneficiary designations. Anything with a beneficiary designation does not go through probate. This would include your life insurance, annuities, IRAs, retirement plans, and also for some of you that may be eligible for what's called a cash balance pension, those also require a beneficiary designation. At the bank, you might have a checking or savings account. Oftentimes that's set up jointly. But let's say you're single or you're widowed, and you want to make sure that those assets transfer to whom you want them to transfer. We would set up a payable on death. Payable on death would apply to checking account and it would apply to your savings account as well. If you've got a brokerage account, this transfers to what's called transfer on death, or TOD. It does the same thing as a POD for a bank account, except that it's a probate-free transfer to whoever you've got listed on the beneficiary designation. We've spoken earlier about the use of trusts. Trusts, when they're funded, when they have assets in them, the assets that are owned by the trust are not subject to probate either. A trust, in a way, kind of replaces the will. Your will is set up to distribute assets to your heirs. Your trust does the same thing. It's just that the trust does it probate-free. So if you've got real estate in another state, or you just want your estate settled in a private manner, then we would recommend a revocable living trust. Keep in mind, your will is a public document, and if you want your documents to be private, a revocable living trust is the way to go. And so you can see a lot of things boil down to how the asset is titled as to whether it goes through probate. And just keep in mind, there are ways of setting up estates so that they're totally probate free. It takes a little work, but it can be accomplished. Thank you.